Hello and welcome to NTIQ TAP. Welcome to this latest webcast. This one is a little bit different to recent ones. It's regarding a bankruptcy case and obviously a bit of case law that we've come across. I'm hoping I'll get the pronunciation right of the case. So it's Lakatamia Shipping versus Hsin, I think that must be. So it's regarding the domicile of a bankrupt, and the bankrupt was on the order of immigration authorities not to leave the UK. So certainly sounds like it's going to be quite an interesting case, doesn't it? So let's have a little look at what it was all about. So in terms of the facts of the case, of course, we know, or hopefully you know, that in order to obtain a bankruptcy order upon either a creditor's petition or a debtor's own bankruptcy application, it must be shown that a debtor, firstly, is domiciled in England and Wales, or at any time within the immediately preceding 3 years, has been ordinarily resident, has had a place of residence, or has carried on business in England and Wales. And this case examines the phrase place of residence. Okay, so bear that in mind as we go through the detail. So Nobu Su, also known as Hsin Su, is a dual citizen of Japan and Taiwan. Among amounts owed to other creditors, he owed the Lakatamia Shipping Company over $60 million US, so pretty significant. In January 2019, upon arriving at Heathrow, Mr. Su had his passport confiscated. He then stayed at different hotels and serviced apartments in London before being committed to Pentonville Prison at the end of March 2019 for contempt of court. Having been released in April 2020, Mr. Su lived in 2 different properties with the permission of 2 different friends. In the meantime, in January 2020, an order was made preventing Mr. Su from leaving the jurisdiction on his release from prison until he had given evidence regarding his assets pursuant to the civil procedure rules. From the moment when Mr. Su arrived in the UK to the moment when he applied for a bankruptcy order to be made against him, he was either subject to restrictions that prevented him from leaving the jurisdiction or was physically incarcerated in prison. At the same time, Mr. Su had attempted to leave the jurisdiction, both by attempting to get on a ferry to Belfast, which of course is outside England and Wales, and subsequently by unsuccessfully applying to court to lift the restrictions keeping him in the jurisdiction. So on the 8th of July 2020, Mr. Su was made bankrupt upon his own application. In September 2020, Lakatamia Shipping applied for an order annulling the bankruptcy order, and in February 2021, Lakatamia applied for summary judgment on its annulment application. Lakatamia's application was unsuccessful at first instance because while the judge found that Mr. Su was not ordinarily resident in England and Wales, he did consider that Mr. Su had a place of residence at one or more of the locations at which he had stayed since January 2019, and of course that included being at Her Majesty's pleasure. Lakatamia accordingly appealed on the place of residence point, with the appeal heard by Mrs. Justice Bacon in the Chancery Division on the 1st of July 2021. So let's have a look at the decision now in that case. So as Mr. Su made himself bankrupt, the court considered the provisions of Section 263 of the Insolvency Act. So note that as Section 265, which is relevant if a creditor seeks to make a debtor bankrupt, contains the same wording, the decision is presumably relevant both to 263 and 265. So taking the above facts into account, the court reached the following conclusions. Firstly, that the place of residence for the purposes of Section 263 and 265 has to be a residence of the debtor and not the residence of someone else. The residence of a third party, which the debtor is temporarily occupying with the permission of that party, will not count for those purposes. Secondly, a residence was one's settled or usual home with some degree of permanence, some degree of continuity, or some expectation of continuity. Thirdly, as part of an assessment as to whether someone has a place of residence in the jurisdiction, it will be relevant to consider whether that person is in the jurisdiction voluntarily. But whether or not the debtor's presence is voluntary will only be on the facts relevant to an assessment in determining residence. It will not be determinative in itself. Fourthly, that said, the court noted the decision of the first instance judge in relation to the ordinarily resident test, namely that being in England and Wales involuntarily could not constitute being ordinarily resident. In this regard, Mrs. Justice Bacon noted that the ordinarily resident and has had a place of residence tests are two separate tests, albeit it may be that the same facts or factors are relevant to both tests. Accordingly, Justice Bacon concluded that Mr. Hsu had not met the jurisdictional test for the purposes of Section 263 of the 1986 Insolvency Act. Therefore, his bankruptcy should be annulled. So, what does this mean for you? Well, the judge's conclusion ensures that a fleeting or transient occupation of premises in this jurisdiction will not be sufficient to be found to be a bankruptcy jurisdiction. So even, well, presumably because he was incarcerated, that doesn't count as having a residence as such, even though it's enforced on him, or because it's enforced on him. Indeed, in order to make to be made bankrupt, in this jurisdiction, a debtor needs to have lived in the jurisdiction permanently for a material or perhaps considerable amount of time. However, what might qualify as sufficient time for these purposes will presumably depend upon the facts. So, as far as we're aware, Mr. Hsu has applied for leave to appeal the decision. So stay tuned. But we thought this was a really interesting case for you. If you tend to deal with more, perhaps the bankruptcy side of things, or like to keep your eye in, it's an interesting one, isn't it? Look out for debtors who maybe aren't kind of bankruptcy tourists as such, but maybe have got some doubt as to their residence and their ordinary domicile. So thanks for joining me. Great to see you again. Thanks for joining me on NTIQ Tap, and I'll look forward to seeing you very, very soon. Thanks very much. Bye-bye.